Hi, welcome to Divorce and Finance 101, a primer for Michigan women going through the process of divorce. My name is Jacki Roessler, and I'm going to be your presenter for this broadcast. And I'm a certified divorce financial analyst, just for a little bit of background on me. I've been a divorce financial advisor for the last over 20 years. My practice focuses exclusively on divorce financial planning. So I only work with clients who are in the process of divorce. I don't manage assets for clients after the divorce. My work is strictly during, and most often clients are referred to me by their attorneys to give them support and education and information to help them navigate their way through the financial issues of their divorce. Just a few housekeeping items before we start. All of the chat features have been disabled during this presentation, which is going to last about a half hour. So if you do have any questions, please write them down as we're going along, and I will and send me an email. My email address will be displayed at the last screen, and I'm happy to answer any questions that you may have. Please visit our website at www.centerfinplan.com for any upcoming blogs and webinars on a variety of different financial planning topics that cover items from year-end tax planning to how to deal with grief and loss, and all issues related to divorce and non-divorce financial planning topics. And one additional word of caution and a disclaimer. So I am not an attorney. I'm a divorce financial advisor. So as a non-attorney, I cannot give out anything that could be construed as legal advice. So this presentation is for information and education purposes only. The information that I'm presenting this morning shouldn't be construed as legal advice. And anyone who is contemplating divorce should seek advice from a qualified attorney that specializes in family law. That's always the best recommendation that I can give to any client. Is the most important thing you can do is find the right competent attorney for your case, because any financial settlement that we try to work out with clients, if there isn't a good attorney involved that really understands the intricacies of family law in the state, and not only the state but the county that you live in, you're really at an extreme disadvantage. So this information, again, is only for educational and informational purposes based on my personal experience working in cases, and it should not be construed as legal advice. So let's begin. Today what I'm going to cover are the three areas of money in divorce. And the reason why I'm covering these areas is that I have never yet, in all of my years of divorce financial planning, sat down with a new client and didn't end up talking about Divorce and Finance 101 at some point during that initial meeting. So it's information that I think, even if clients have heard some of it before, it's good to hear it all again. What are the three basic areas of money that we're going to be addressed in your divorce case, so that you know what the basic parameters are. You can't really talk about deviating from what's normal if you don't know what the typical scenario is. So I find this to be an area that I have never had a new client come in where we didn't cover this. So this will be hopefully a good resource for you. The three areas of money in divorce are child support, spousal support, and property division. And pretty much all of the issues that come up that are financial related issues can fall into one of these categories. So I'm going to give you basic information today that you could look up in a book or look up online if you were looking at Michigan law. And again, every state has different laws related to divorce. So when I'm presenting today, I'm presenting information based on the law as I understand it, based on my experience in Michigan. But if you live in Ohio or if you live in California, there might be a completely different set of rules that apply to you. So this is really very specifically focused on Michigan and for those people that live in Michigan. Okay, so let's start at the beginning. Child support is the easiest one to explain, so I always start there. In Michigan, like every state, child support is based on a formula. So if anyone is curious about what their child support may be, you can go online and look at the State Bar of Michigan. You'd have a link to go to there to calculate what the child support amount should be. And in our state, it's based on a formula that takes into consideration the income of the high wage earner, the income of the low wage earner, so of the mother and the father, what the parenting schedule is with both parties, and also what the cost is for health insurance and dependent care, if one or both are paying for either of those expenses for the children. So those numbers are plugged, and also the ages of the children. Those numbers are plugged into a formula, spits out a recommendation, and that's pretty much the number. There's not a lot of wiggle room around child support. Where we do get into some wiggle room is in making it from a very black and white area to a gray area is when we talk about someone who's been out of the workforce for a significant amount of time and maybe currently isn't earning an income. What do we use for that person's income in this formula? And so one person, my client might be the low wage earner, the stay-at-home parent, and they might say to me, well, I can't go out and earn a job, even though I have even though I have a degree in chemical engineering. I haven't used that degree in the last 15 years. So I think that there should be no income, what will be referred to as imputed to that person or to me in that calculation. Whereas the client's soon-to-be ex-spouse says, wait a minute, you could go out and get a job right now and you could earn $25,000 a year. At the minimum, maybe you could even earn as much as $50,000. So that's where we get into some gray area in the child support formula in terms of discussing what is the appropriate income that should be used for each party. So that is the one area that is slightly gray. What you need to know about child support is that it is non-taxable income to the person receiving it and non-deductible to the person who is paying it. So what that means is if I receive $2,500 a month in child support, I get to keep $2,500 a month. I don't have to pay any taxes on it the way that I would have to pay taxes on my paycheck. Similarly, the person who is the payor, if they have to pay $2,500 a month, that's what it costs them out of pocket. They don't get to deduct that on their taxes. So that is a non-taxable income source for the recipient. And child support is always modifiable. And what that means is that the court's door is always open to come in and have that support amount changed if there's a significant change in financial circumstances for either party. And that's because the court is always worried about what is in the best interest of the children. And so if one person, let's say, becomes disabled and loses their job, that's a significant change in financial circumstances and may be a reason that child support needs to be adjusted. Similarly, if someone wins the lottery, that might also be a reason for child support to be adjusted or modified. Now here's the tricky part. What child support does not cover? So what I find when I sit down with clients is that they assume that child support is actually going to take into consideration their child's expenses. And if you recall, when I was describing the formula to you, there wasn't anywhere in that formula that you needed to input or your attorney would input what your children's expenses are other than healthcare costs and any daycare or dependent care costs that you might be paying out of pocket for them. Aside from that, if your child has private school tuition, has some expensive hobbies, most of the kids that I have young elementary age children, and I know that they have a lot of expenses. They take violin lessons, they take dance lessons, they do hockey. I'm in Michigan, so we have a lot of kids that play hockey. But all of those expenses, they are not taken into consideration in the child support formula. The same is true of college savings and also expenses for adult children who are not minors, who are going to college. That is not part of the child support formula in our state, in Michigan. So if you have private school tuition expenses and you have expenses coming up that you haven't considered how they're going to be paid, now is the time to get that on the table. So one of the things that I would help clients with when they're in the process of divorce is pinpoint for them what are the things that are not covered by the child support guidelines and what expenses do we need to make sure that we discuss while we're going through the divorce process so that you know in advance, you know what, my child may or may not be able to continue in this expense, and it's better for you to know that up front. For example, I had a client in the other day that assumed that the private school tuition was going to continue to be paid because that had been paid throughout the marriage. There is no requirement by either party to continue maintaining any expense for the children. So I always recommend that we get every expense that we can think of on the table now and talk about how it's going to be covered in the future, and that there be a very specific agreement in place about how those expenses would be covered. Even expenses that may not be occurring right now. So I have young children. I know that eventually they're going to have a cell phone. They're going to have, we need to figure out how we're going to handle future car payments and items like that that are not, I don't want to be in a position if I'm getting divorced where I have to suddenly figure out how I'm going to pay for all these costs for my children on my own. Better to discuss it up front and figure out how we're going to address those items within the context of the divorce. Okay, so moving along. The second area of money in a divorce is more complicated than the first area, and it is spousal support. Spousal support is this, what we call in Michigan, it's the word we use for alimony. It's the same thing. In other states, they call it maintenance, spousal maintenance. In our state, it's referred to as spousal support. But for all intents and purposes, from a tax standpoint, it is alimony. And what's really important to know as compared to child support, if we contrast and compare those two different areas of money in a divorce, child support is very black and white based on a formula. In Michigan, we do not have a formula for spousal support. So there are several different factors that the judges can take into consideration when they arrive at a number and a length, an amount and a duration for spousal support. Now, as a side note here, taking a step back, I want to point out that when I say the judges can consider, the vast majority of cases in Michigan do not go to trial, and where they're in front of a judge for a judge to make a decision. So in the county that I live in Oakland County, I think less than 2% of all cases actually go to trial. However, if you're working with a qualified family law attorney, they're going to know what Judge X tends to do in situations where they've had a similar case fact pattern. And so it's very, again, really important that when you're getting divorced, you have a good qualified experienced family law attorney that can guide you through what would be the normal factors that should be taken into consideration. The two largest factors are financial need, and financial ability to pay. In order to quantify what your financial need is, and the onus is on you, if you're asking for spousal support, you need to be able to give your attorney the tools to show how much support you need. I actually have a previous webinar that I taped that you can go back and listen to if you haven't heard it yet on cash flow planning, where there's detailed information on how you can give your attorney the tools for them to take into consideration and prove the case of how much you need financially. Now, ability to pay is also one of the largest factors. So I can ask for the moon, but if my ex-spouse does not have the financial ability to pay based on his income and his own personal expenses, then that's not going to be relevant. So we need to try to find a way to come up with a number that one person might have a need for, the other person has the ability to the financial ability to pay. Other factors that would be considered are the length of the marriage. In my experience, anything over 10 years is considered a long-term marriage in our state and a candidate potentially for spousal support. If there's an income differential between the parties is another factor, an income earning capacity. So my educational background, I might have a doctoral degree, but if I haven't used it in 20 years, that's something that should be taken into consideration in some way. The fact that I have that degree is also one of the factors that can be taken into consideration, as well as issues that affect, sorry, I want to fast forward a little bit here. While we're talking about formulas, and then we're going to go back to that slide also. But again, one thing that's really important that I would stress really highly is that we do not have a specific formula in our state for spousal support. So it's very different than child support. It's also different in that not only do we not have a formula, but generally speaking, alimony or spousal support is treated as taxable income to the person who's receiving it and tax deductible to the person who's paying it. Now, as I'm giving this webinar, that deductibility has actually been one of the items on the table for tax law changes that are being proposed in the House and the Senate. From what the news that I've seen recently, it looks like that the removal of alimony as a deductible item for your taxes looks like that's not going to be on the table. But so we're going to just talk about the current law as it is, and you need to keep your eyes open to see if anything does change on this in the news. So as far as the deductibility goes, if I'm going to receive $2,500 a month in spousal support, I don't get to keep that full $2,500 a month. Depending on what income tax bracket I'm in, it's treated as ordinary income always, and I will pay taxes on that income when I receive it. So maybe I will only get to keep $1,750 a month out of the $2,500 after taxes are taken into consideration. So I had a client once that said to me, I prepared my budget. This is the offer. I need exactly this amount based on this is what my earnings are. This is what my financial need is. Here's my budget. My ex-husband says that he's going, or my soon-to-be ex-husband, he's going to pay me the exact amount that I need to cover the difference. And when I looked at her budget, I said to her, okay, but you didn't take into consideration that you have to pay taxes on whatever he pays you. So if he's paying you $2,000 a month and that's the money that you need, you're not going to get to keep the full $2,000 a month. Plus, every year expenses go up based on the cost of inflation. It costs more to buy gasoline. It costs more to go grocery shopping. Healthcare costs go up every year. But nowhere in her budget had she taken into consideration that the cost of living was going to go up. So those are the types of areas where a financial advisor comes in and can help divorcing clients try to determine what amount they really need and analyzing the tax impact of receiving spousal support. On the flip side, when someone says, I can't afford to pay this amount of spousal support, it's important to be able to tell them, well, it's actually going to cost you this very specific dollar amount in after-tax dollars. So if you're paying $2,500 a month and you're earning, say, $150,000 a year, maybe it's only going to cost you $1,500 a month to pay after you get the deduction for that. So that's really important to know when you're negotiating a settlement. And that's one of the things that attorneys will rely on financial advisors for support in is how much is it really going to cost the parties to pay the spousal support out of pocket, and how much does the other side actually get to keep. The other thing that's important to know about spousal support is that it can either be set up as modifiable or non-modifiable with respect to the amount and the duration. So as to how long it's going to last, and as far as the amount. And if you recall, child support is always modifiable because the courts are always going to keep the best interest of minor children at the very forefront of those financial decisions. When we're talking about spousal support, it can either be modifiable or non-modifiable. And that would be something, again, to discuss with your attorney and hopefully your financial advisor if you're working with one. What are the pros and cons for your particular situation of it being locked in at a certain set dollar amount that you know you can count on for a certain number of years? Or would it be better for you to have it modified if you think that your income may go down and you're the person that's going to be, let's say, paying spousal support, and you think your income may go down in the next year or two based on the economy, based on changes in your work environment, you might want to leave it as modifiable or changeable based on a significant change in financial circumstances. So those are all different questions and comments that and conversations that you should be having with your attorney while you're going through the process. And really important for you to know that even though there are a couple different software programs that many attorneys and judges will use to give them a starting point for what spousal support should be, we don't have a formula in our state. So they can give you an idea of what you would start with, but they can only plug in 6 of the 11 factors that the courts can look at, and they're all quantitative, not qualitative factors. So factors such as how long you've been married, what your current income is, are things that you can plug in. What you can't plug in is the fact that you might not have used a degree for many years, or that you have some health issues that prevent you from going out and working full-time. Those are things that you can't plug into a formula. Similarly, nowhere in that formula that you would be looking at for those two software programs that I mentioned. Does it even ask you for what your living expenses are, for what your ex-spouse's expenses? And those are key factors in the determination of spousal support. And these are the other factors that can be considered: age of the parties, fault, income earning capacity, education, financial need, length of marriage, health of the parties, and financial ability to pay. And as I said, financial need and financial ability to pay. Those are the two big ones, and that's why I've put them here in bright red so that you can see that. And this is an example of the current tax law for spousal support and alimony, keeping in mind that the tax law may change at some point in the future, and alimony may no longer be deductible going forward for cases that would settle forward. It wouldn't be backwards looking for agreements that have already been put in place. So if Greg pays Susan $3,000 a month in spousal support, we need to ask how much does that cost Greg out of pocket, and how much does Susan actually get to keep? And I've got this picture here of a crystal ball, things that we need to take into consideration when looking at modifiability of spousal support are things that, if we want to lock it in, we are assuming that we don't know, we know what's going to happen in the future. Financial considerations would be, what if there is what if someone has a health issue that they don't currently have? What if they're diagnosed with something that doesn't allow them to go out and work? What if they're in an accident? What if the job market changes and suddenly where the job market was open and whatever your career was, now it's suddenly closed? Those are things that we just can't determine today. And so there is certainly a risk to locking in spousal support and making it non-modifiable where it cannot be changed. But you have to always, again, weigh out the particular risk and reward in your specific situation. So I always caution people, just because your friend got a settlement agreement where they had 7 years of spousal support locked in for 7 years in a set dollar amount that was right for them, that may not be right for your particular financial circumstances. And in some cases, we look at a situation where one person feels like they can't get past that idea of paying spousal support and writing and having that check come out every month. And we might look at even what is a partial buyout or a lump sum for all or some of the spousal support amount. However, if there's a buyout, generally what that means is that the door is locked and spousal support has become non-modifiable if you take a buyout. So those are all different financial considerations that are discussed with a financial advisor and your family law attorney. Now, in Michigan, we're going to move into the third area of finances in divorce. And in Michigan, we live in what's called an equitable division law state. If we lived in California, that is a community property state. And in California, everything is divided 50-50. We live in what's called an equitable division state, not a community property state. And equitable means fair, not necessarily equal. So there's a presumption that the division of property in the marital, throughout the divorce process is going to be fair. Now, my idea of fair might be something completely different than the other client's financial advisor or attorney may think is fair. So we get into issues there in terms of what is fair. The largest number of divorces that I've worked on, and I've worked on more than I can even count since in the last 20-some years I've been doing this, most of them do pretty much end up at a 50-50 split of the marital property. But it's a question of which are the right assets for your particular financial needs, rather than just splitting everything right down the middle. Is it better for you to have more cash up front, less retirement assets? Or is it better for you to have more retirement assets and less cash up front? And we would take a look at all of those different considerations for your specific case. There is a difference between marital and separate property in our state, and I'm going to cover that. And I'm also going to cover the issue of there being no tax on transfers between spouses in property pursuant to a divorce. So if I have money in a Fidelity brokerage account in my name, and my ex-husband is going to receive 50% of that account, when we pick up and transfer that asset from me to him, that is not a taxable event. He doesn't pay taxes on that as coming in and I don't get to deduct any of that. There is no tax due on transfers of assets between spouses pursuant to a written divorce decree. Anything that accumulates during the marriage, no matter whose name it's in, is generally going to be considered marital property and up for division in the scales that are going to flip one way or the other between. We'll go along with that. The same case here, we've got Sue and Greg, and in this situation, anything that is accumulated during the marriage, again, is going to go into that pot that's going to be divided on an equitable basis between the parties. So I earn a pension at my job. I say, that's my pension. I'm the one that went to work every day. I'm the one that put in the time. I'm the one who has the relationship with the employer. That's my pension, and that's my asset. Well, the law says, again, you need to check with your attorney because there are going to be gray areas in this, and I'm not a lawyer, but in most cases, that asset accumulated during my marriage, that is a marital asset. Now, I might try to negotiate that I keep that whole pension as my portion of the marital estate, but then that's going to go on my side of the scale. And if, let's say that this is for Sue, she wants to keep her whole pension. That goes on her side of the scale. Greg would need an offsetting asset of equal value so that they would be in an equitable position. And that may or may not be the best situation for Sue. People often have emotions attached to certain assets. And as a financial advisor, I try to convince them to take the emotions out of it and treat this as if it was a business splitting up and not a relationship. If this was a business that was splitting up, you wouldn't be worried about whether or not you had that personal attachment to this specific lamp that was purchased or some specific item. You would be looking at what's best for your financial future. And so that's what a financial advisor in a divorce case is trying to help support their client to determine, is it in my best interest to keep this asset, or am I holding onto this because I have an emotional attachment to it? And we want to look at everything in a very kind of a black and white, let's put it on paper and take a look at the actual real numbers of you keeping this asset at the expense of everything else. So oftentimes I'll have a client that says, I'm going to keep the house no matter what. That's my safety and security. And I would push back on them and say, let's see if you can afford it. Because if you can't afford it, the stress of you not being able to afford to make the electric payments and keep up the landscaping is going to be much worse for you and your children than downsizing now when you can be prepared. I always tell them that knowledge is power in a divorce case as in anything else in life. Okay, so, and there's a difference between marital and separate property also, and I've got a few things to cover, so I'm gonna go through this next section fairly quick. Anything that is, so here we have a marital, in the left-hand side of this screen is a circle. In the circle is the theoretical pie. It doesn't look like a pie, it looks more like a moon, but let's pretend it looks like a pie, and it's going to be divided pretty much 50-50 between the parties. Anything that goes into the left-hand side of the screen is going to be marital property. So anything that's accumulated during the marriage, including assets and debt, no matter whose name it's in, goes into this marital pie that's going to be divided equitably between the parties. However, in our state, there are exceptions to that, and anything that is treated as separate property can be considered something that is outside of the marital estate and would not go into the consideration of an equitable division. So typically, and again, this is a very gray area, the difference between separate and marital property, and the reason why you need to have a good divorce attorney to help guide you through what could be considered and what could be considered separate and what could be considered marital. So if anything that is gifted to you and you never commingled is something that could be considered separate. Anything that is inherited and never commingled, and everything that you bring into the marriage and never commingled could be considered separate property and not up for division in the marital estate. So if my aunt died and she left me $10,000 in an asset in my name. I never added my husband's name to that account. It was never commingled. That could be considered my separate property. Similarly, anything that is gifted to me. So I came home one day and my husband, let's say, gave me an expensive piece of jewelry as a birthday gift. I would say that was my gift, and that should not be considered marital property. And it's not like I get that jewelry and he gets an offsetting asset in the mutual fund. However, this is where it gets a little bit gray. He might push back and say, well, wait a minute, that wasn't a gift, that was an investment. So that's where some of those things can get a little bit gray. Also, anything that was brought into the marriage and never commingled. So let's say I get married and I say what's mine is yours, what's yours is mine, I'm in love, and I'm going to take the title of my house and change it from my name to joint title. That's called making a presumptive gift to the marriage, and now that asset, which may have been considered my separate property and not part of the division of the marital estate, could now be part of the marital estate. Now, again, there are lots of extenuating circumstances, and it depends on the circumstances of your case and the timing of when all of these transfers took place. As well as how much separate property you have compared to the marital estate. If I have $1 million in separate assets and our marital estate is only, let's say, $500,000 worth of assets, then there's a larger reason for me to receive more than 50% of the marital estate. That might be fair if one person has a large amount of separate property, or for us to even invade that separate property to provide for my financial security. So again, this is a very gray area and an area where you need a good divorce attorney and a good financial advisor if there are issues like this. One thing I do want to touch on before we finish up here is that we want to make sure we compare apples to apples. So $100,000 in an IRA account is worth less money than $100,000 in a brokerage account or $100,000 in the bank in cash. Because when we take the money out of the IRA account, you have to pay ordinary income taxes on that, whether you take it out today or in the future. Whereas money that comes out of your bank account in cash, you don't have to pay taxes on. So we want to make sure that we do take taxes into consideration when we look at the marital estate. So one of the things that I do as a financial advisor is help my clients put together a list of the marital assets and debts, taking into consideration any debits that should come off of assets, whether it's anticipated taxes for retirement distributions or taking a look at the cost basis of different assets inside of brokerage accounts. Those are all things that need to be considered. And most important of all, what are the right assets for your particular situation? These are the things that a financial advisor is really going to be beneficial in terms of, have you taken taxes into consideration? Are you still going to be able to retire on time? That's something that you want to think about while you're going through the divorce process. It's not something, your divorce isn't going to impact your finances just today, but also in the future, especially if you're getting close to retirement age. And so you always want to look at how will the settlement affect your long-term financial well-being. And that is something that a financial advisor will be able to assist you with. So my final thoughts on this topic, this is just an introductory topic, a primer, if you will, and so I'm sure that in the future I'll be doing some more advanced topics that dive a little bit deeper into child support and children's expenses, spousal support, the differences between separate and marital property. But for now, if you walk away with 3 things, I hope you walk away with the knowledge today that your settlement agreement is final and typically cannot be changed. So you need to make sure when you sign on that dotted line that it works for you not only today, but also in the future. The person that it matters to the most about whether or not the financial agreement works for you today and in the future is you, and not your attorney. No one else is going to have to live with a settlement aside from you. So you want to make sure that before you sign anything, there's never a stupid question. There's never a reason not to get another opinion if you're concerned. Make sure that you can live with it now and in the future before you sign it. And you always want to arm yourself, number 2, with all the facts that you need to make an appropriate decision. So taking the emotions out of it, giving yourself all the information that you need, whether that means that you get additional outside coaching or that you make sure you have all the documents, the financial documents, and they've all been reviewed, and you understand the positive and negative impact of each choice that you've made. And 3, most important, knowledge is power. Better for you to know upfront that you can't afford to keep the house than find out in 3 years that you're going to have to sell it and eat maybe in a down market and pay all the closing costs and commission yourself. Knowledge is very empowering. I've never yet had a case where someone said they weren't glad that they knew upfront what their financial picture was going to look like before they made any financial decisions on their divorce. So again, thank you for listening today. Here's my contact information. If you have any specific questions relative to your case, feel free to send me an email and check out our website for any future webinars and blog posts on topics that may be of interest. Thanks for listening.